If you are applying for a marriage-based green card in 2025, listen carefully. Approval no longer means safety. You can have your petition alien relative form I-30 approved and still be put in removal proceedings. The rules have changed, and love by itself is not enough. In this show, we'll break down the new risk, the red flags officers look for, real life denial cases, and the survival plan you will need to protect your family. I just ask of you one favor. If you haven't done so previously or haven't done so as yet, please like, share, and subscribe to the channel. Let's get into it. What's changed? On August 1st, 2025, USCIS updated its family-based guidance. An approved petition does not protect you from a notice to appear, which is known formally as the NTA. Couples who thought approval meant security are now exposed. This is a fundamental shift from family unity to strict enforcement. Even small mistakes, like using an outdated form, have caused denials. This is an ideological shift on the part of the administration. And it's very obvious what the objective is. The government is very much focused on ensuring that only legitimate persons do go through the process to obtain a green card via marriage. On August 19, 2025, a new rule took effect. So-called anti-American activity now weighs against you. Your social media is being screened. Posts that may seem harmless can be flagged and used against you. And minorities and vulnerable groups feel this the most. So I suggest you keep your digital footprints clean. Be conscious of what you put in the social media space, because it may come back to harm you when you least expect. Now, there are about 6 big tripwires that gets marriage cases denied. Number 1, inconsistent relationship evidence. Thin or staged photo evidence, contradictions in documents. Here's an example of a draft case. A couple submitted photos all taken on the same day. Officers flagged it as staged. Approval denied. Number 2, interview contradictions. Spouses giving different answers while being interviewed because of the pressure that they're feeling, or because they may not know each other. Think about this as a draft case. One said they met in July, the other September. You know what happens? Denied. Number 3, status problems and inadmissibility. Prior unlawful presence. You came, you overstayed, now you're trying to find legitimately. You get removal orders. You were told to leave the country, you didn't leave, or you had misrepresentation. You lied. Are all cases for denial. Number 4, medical form, I-693 mistakes. Outdated or invalid medical exams, case for denial. In June 2025, USCIS clarified all exams cannot be reused once denied. Number 5, wrong form editions or sloppy packets where you made your application. Using outdated editions or incomplete submissions is a no-no. Think about this draft case. A couple thought love was enough. Missing documents sank their petition. Number 6, digital footprint problems. Your social media flagged as anti-American. On your social media, You have information there which may say something negative about maybe the administration, the country. Your social media will be checked. And if quote unquote anti-American is found, it could be a case for denial. Now, officers are trained to spot red flags. What are some of those red flags? Big age gaps with little history. She's 40, you're 20, you don't have history together. Big situation where cause for question, cause for concern, cause for further scrutiny. Very short dating before marriage. You've only met a couple weeks ago. You've only met a month ago. That's also another red flag. A quick marriage. You just got into the country 2 weeks ago, 3 weeks ago. All of a sudden, you're getting married. Not a cause for red flag. No shared finances. You have no bank accounts together, no leases together, no insurance policies together, nothing commingled, nothing integrated. Not a cause for concern. Not a red flag. Stage photos. You took photos all on the same day, and those are what you provide as your evidence. And also things like little family involvement, where your family and your spouse's family do not connect. There's no linkage. There's no history. It's clear that in these situations, they will cause alarm and red flag for the officers, which would require further scrutiny, could lead to denial. And here's what many do not expect, which is really interesting. And it goes to the more intrusive way in which the administration is now operating. It's almost like what we call an auditor. It's very intrusive. One example, home visits that many would not expect. Officers can arrive unannounced to check if you're living together. They'll check closets, bathrooms, and living areas for signs of shared life spaces. They'll look for clothes, mails, bills in both of the person's names. They may ask casual questions about daily routines. Here's an example. Officers flag missing clothes and bills with only one name. If your home doesn't look shared, they can question your marriage. Couples have to think about this. This is an imperative. You must prepare your home to reflect a genuine shared life. Joint mail, shared wardrobes, photos around the house, things that show that you're actually a couple. Now, there's some good news. Officers look also for what we call positive evidence. Such evidence includes joint bank accounts, leases, utilities, insurance policies. Some of the things which are red flags, they're looking for the positive nature of these things, which shows that you're a couple. Joint travel records together. You go on vacation together, you travel to conferences together, you travel to family outings together, or family events together. Those records are also things that are positive evidence. Photos across time in different places, not staged in one day. Affidavits from family, friends, pastors, substantiating that, are indicating that you're a couple. And then there's shared responsibilities, like you have children or you have guardianships, you adopt a child together, you have a child together. That's also positive evidence that officers can use to substantiate that you're a legitimate couple. Now, for minority applicants, minority and non-traditional couples face higher scrutiny. Cultural differences, language barriers, even activism can trigger bias in how officers view your cases. And we've seen real life examples, not only in the marriage arena, where activism have got individuals in trouble with immigration authorities. What's your defense? Dense documentation. Make sure their documents are aligned and they're consistent. And also, last but not least, is legal support. As it relates to, if you're a minority applicant or any applicant, you should have a lawyer or try to obtain leave of services in some respects. Now, there's a triple check survival plan, which individuals should think about. Here is that plan. Based on both official guidance and draft examples, survival requires a triple check plan. Step 1, pre-file audit. Verify that you have the newest form editions. Make sure you know what the fees are, and also ensure what the eligibility requirements entail. Step 2, an evidence wall. Build a binder with chronological proof, photos, bills, leases, travel. Step 3, medical and forms. Submit a fresh I-693 exam with your I-485. Step 4, digital hygiene. Clean up your social media. Delete risky posts. Step 5, interview prep. Show that you're trying to make yourself prepared for this interview. Rehearse timelines and details so answers are consistent. I would call it invest in yourself in ensuring that you're prepared for this because it's important. Draft examples show how couples who over-prepare with evidence often succeeded, while those who rush or rely upon love often faced denial. Now, if you get an RFE, which is a request for evidence, or a NOID, a notice of intent to deny, respond surgically by addressing every single point with labeled evidence. This is very important. If you're requested for evidence in the RFE or notice of intent that your approval may be denied, make sure whatever it is that's being provided in terms of what you need to provide, that you address every single point that relates to the denial or the evidence requested, and make sure that those are on point. If you get a notice to appear, which we hear a lot about nowadays in the news, that means you have to go to immigration court. You should immediately contact an attorney. Again, if you get an NTA, which is a notice to appear, contact an attorney immediately, because this means you have to go to immigration court. Now, in closing, I'll say this. Marriage-based immigration is now what I would consider a gauntlet, because it's now one of the most scrutinized areas of U.S. law. The message from the drafts was clear in terms of the examples provided. Love is just not enough. Applicants must double check and triple check their documentation and their evidence to make sure they're in order. You should prepare like everything depends on it, because it just might. A careless mistake can lead directly to what you don't want, which is deportation. Again, be prepared, provide the required information, stay up to date, and make sure whatever is requested of you, you provide timely, immediately, substantively. Thanks for being here. Appreciate you being here. Again, please like, share, and subscribe to the channel. Peace out.